In Sheboygan County, Michigan, Isidro Eisler was charged on a multi-count complaint following an encounter with law enforcement officers. The charges include fleeing and eluding, resisting and obstructing an officer, and operating while intoxicated. Officers initiated the stop after observing Mr. Eisler driving a vehicle with an inoperable headlight, a civil traffic infraction. The prosecution contends that Mr. Eisler turned off his vehicle lights, accelerated into his driveway, and fled into his home while disobeying verbal commands to stop. However, the defense has moved to suppress the evidence, arguing that officers conducted an unlawful, warrantless entry into the private residence. Defense counsel James Gilbert asserts that the officer's entry into Mr. Eisler's house violated the Fourth Amendment. The defense maintains that any initial exigent circumstances dissipated once officers stepped outside, secured the perimeter, and waited 15 minutes without obtaining a search warrant. The hearing was held before Judge Aaron J. Gauthier in the 53rd Circuit Court of Michigan. The state presented its arguments through prosecutor attorney Melissa Goodrich, contending that Mr. Eisler's flight from the traffic stop constituted an ongoing hot pursuit of a fleeing felon.
All right, well, let's call People v. Isidro Eisler, 25-7105. This is for a docket call and also a defense motion to suppress evidence. Go ahead, Mr. President.
I thank you very much. This was started out as a headlight that was out. Law enforcement goes to flip around and my client is virtually to his house, pulls in, and law enforcement is in hot pursuit. My initial argument is that before entering the property, I believe that they needed a warrant at that point in time. This was initiated on a civil infraction, and based off of the officer's testimony and the location of where they were at, I don't believe a hot pursuit would have ensued, should have ensued. However, if the court does not agree with me on that, the facts are even more interesting. It's that law enforcement chases my client into the house, proceeds into the house. Again, I believe a warrant would have been required at that point in time. But then after the house secures the main floor, assuming that my client was in the upstairs, leaves the building first, as the officers testified, approximately
waiting for backup, right?
What's that?
Waiting for backup.
I believe backup had arrived. They went out to coordinate with them.
Oh,
okay. And so they went back out, and at that point coordinated a plan, I should say. And so definitely at that point in time, I would argue that the hot pursuit is over, and any further investigation from that forward needed a search warrant, which was never procured. Then the officers re-entered the building, and at that point convinced my client to come from the upstairs, which led to a lot of the things that he was arrested for. So my argument is that definitely without that search warrant on two separate occasions, that this arrest was unlawful and needed further a warrant on at least two different separate occasions. Thank you.
So the remedy would be to suppress any of the evidence that was obtained as a result of the entry. That would be, I presume, evidence as to the misdemeanor counts for the intoxicated driving and the open intox.
That is correct.
This motion wouldn't have any effect on the count one fleeing and eluding, is that correct? Because that all occurs out on the roadway.
Well, identification, Your Honor, would be pretty key.
Okay, gotcha. But as to counts 2 and 3, I wonder, and I don't know if that would even require, I mean, maybe that's a separate motion if you prevail on this one, whether if you prevail on the entry issue, what effect that may have on counts 2 and 3 for the R&O. So I don't know, maybe that's a question more for the people on what's the factual predicate for the R&O, because some of the commands that were disregarded occurred inside the dwelling. So if the police are not lawfully in the dwelling, that would undermine those charges.
That's my argument.
But some of the commands, I don't know whether from both officers or not, but I think the testimony was at least one of them is giving a command in the driveway to stop, and maybe he's still outside at that time. So I don't know whether you've had a chance to analyze the effect on those charges, or if this is just sort of step one in a possible strategy where we're headed.
It's very much step one, Your Honor. However, depending obviously on the court's ruling, I'm arguing that anything, first off, I thought a warning before entering the property was necessary because of what started this arrest.
So let me ask you, I I find the first entry to be super interesting legally. Here's my question. And so the prosecutor gets a head start thinking about their answer, I suppose. In Lang v. California in 2021, the U.S. Supreme Court said that the hot pursuit rule does not apply to misdemeanors, and the pursuit of a fleeing misdemeanor suspect does not categorically qualify as an exigent circumstance. There has to be some showing of an emergency, such as imminent harm to others, destruction of evidence, or escape. But in that case, the act of fleeing in California was a misdemeanor crime. So my question is, if a fleeing misdemeanant does not allow the hot pursuit rule to apply, is that altered? Or what's the state of that rule in Michigan, where fleeing is itself a felony? Must you have committed a felony and be fleeing, or is the act of fleeing being a felony sufficient to trigger the hot pursuit rule? By my check, no reported or unreported case in Michigan has yet discussed or cited Lang v. California. So what's your thoughts about fleeing misdemeanors in Michigan?
Well, my argument would be, Your Honor, is that
fleeing civil infraction committers.
That's I guess my argument is that I would say that it goes to the base of why the whole thing started versus what escalated into it. So here we're turning around for a civil infraction, and supposedly my client took off. I would say I'm arguing that it's the initial crime that's being investigated that would control whether or not the hot pursuit language or statute would be invoked. So thus, this was merely a civil infraction. There should have been a warrant before going on that.
Mr. Gilbert relied on the underlying infraction being a civil one, which, according to him, rendered the warrantless entry into the residence unlawful. Under the Fourth Amendment, for a warrantless entry to be lawful, law enforcement would need probable cause combined with exigent circumstances, such as an immediate emergency. By bypassing the requirement to demonstrate exigent cause prior to entering the property, the officer's warrantless search was invalid. In this case, the officers did not enter the residence only once, but twice without a warrant. Judge Gauthier expressed his concerns regarding the counts of resisting and obstructing. Under Michigan compiled laws 750.81d, obstructing an officer requires that the officer was acting in the lawful performance of their duty. In this scenario, the legal issue hinges on whether the commands to stop given by the officers occurred while the defendant was in the driveway prior to the potential Fourth Amendment violation inside the home. In the Supreme Court precedent Lang v. California, the U.S. Supreme Court determined that fleeing a misdemeanor does not categorically justify a warrantless entry under the exigent circumstances doctrine, requiring police to show a specific emergency such as imminent harm to others, destruction of evidence, or escape. Mr. Gilbert reinforced that a warrantless entry was not permissible under these circumstances, originated by a civil infraction.
All right, thank you. Ms. Goodrich, what's the people's position?
Thank you, Your Honor. I think this is a very fact-driven case. I would ask that the court deny the defense motion. I agree that initially what caused the officer's interest in defendant's vehicle was an equipment violation. The officers then did a U-turn to position a patrol vehicle behind his Avalanche. At that time, he then extinguished his lights and accelerated rapidly. They then activated their overhead emergency patrol lights. He refused to stop. He turned his lights back on again and then turned into the residence. At that time, he exited his vehicle quickly and tried running in the house. Law enforcement was yelling loud verbal commands to stop. So at this point, we have two felony hot pursuits going on for two felonies. We have a fleeing and eluding that he did with his vehicle, and then when he exited his vehicle and the police are chasing him to the door and telling him to stop, we have a resisting and obstructing.
Well, then, Mike, I have the same question to you. In Lang v. California, the U.S. Supreme Court said the hot pursuit rule doesn't apply to a fleeing misdemeanor suspect. So what does that mean in Michigan? If the flight itself is a felony, how could you ever have a fleeing misdemeanor in Michigan? Is there not such a thing?
I don't believe that there is a misdemeanor fleeing and eluding crime.
Well, if I'm committing a misdemeanor and then I flee, what am I?
Well, there's two felonies going on because you have the fleeing, eluding, and you have the resisting and obstructing. So I don't even think that's a question for this case because there are two felonies. It's not just the fleeing, eluding that they're pursuing at this point.
So that's a very legally fascinating question as to the first entry. But what about the second entry? They enter the home and obtain no evidence. So really the first entry, even if it was a violation, there's no remedy that could be crafted for the first entry. Then they exit the home and wait 15 minutes before they go in. Hasn't any emergency dissipated at that point and they have time to get a warrant?
No, Your Honor, because we continue on with the facts that occurred. So now we have a fleeing, eluding, and resisting, obstructing. He enters the house and tries to push the door shut. The law enforcement blocks the door. Then he pushes law enforcement. So the danger level is escalating here the more time that goes on with the case. Law enforcement then crosses the threshold. The defendant immediately is going up the stairs of a dark house. Law enforcement decides at that point, we need to call for backup. We need to secure the perimeter and wait for that backup before proceeding through a dark house where the defendant now is hiding upstairs.
So why can't they also wait for a warrant?
Well, Your Honor, I think that we're still in a hot pursuit situation where they go outside, they see further evidence. Okay, now we see an open beer can through the window of the vehicle. We're trying to call out to this defendant who just pushed a law enforcement officer and fled and resisted. Trying to call him out through the window to de-escalate the situation to come out. Instead, he uses his truck key remote to lock his vehicle. He continues to be non-compliant. He grows increasingly unpredictable. And then at that time, the deputies re-enter the house to execute the arrest. They have brief negotiations at the stairway, and then he does walk down and placed under arrest. He agrees to a PBT of 0.102, and then he also agrees to the chemical test rights by saying, I refuse nothing. I don't think that the Fourth Amendment requires the defendant who's remained a dangerous active threat for them to have to stop to go get the warrant, not knowing what he's going to do next and what he's done.
Who's he a threat to at that moment in time?
He's a threat to the officers.
Who are outside the home?
Correct. Trying to establish a safety perimeter. They couldn't just simply leave them after everything that's occurred and what he's done.
No, I'm not saying they need to leave. So is there any imminent danger to somebody in the house that they're aware of?
Your Honor, him, because thus far he's been unpredictable. They don't know what's in that house. They don't know if additional weapons are in that house. They're outside the house, but they don't know what he's going to do next.
Okay, is there any imminent destruction of evidence that the officers are aware of?
Your Honor, the courts have already ruled that the blood test, that would not be an exception. So we're not arguing that. It's the fact that the officers here sought safety first. And I don't think the Fourth Amendment requires them to not seek safety first. And by exiting the house and waiting, having backup and having a more safe way to continue to pursue him.
What if it took 45 minutes for them to consult with backup and come up with a safe plan to enter the home? Would it still be your position that no warrant is required despite a 45-minute time gap?
I think the court has consistently ruled that, reasonableness should certainly come into play. I think that if there became an unreasonable amount, then that would be different. I think that the police responded within a reasonable time to provide backup to those officers who were in the dark house with a defendant who had just pushed one of the officers after fleeing his car and running across to the door to escape them.
So let me ask you another question. In Langley, California, they only had to address fleeing misdemeanors. I mean, the facts are very similar. In Langley, California, the suspect drives past a patrol vehicle, listening to loud music with the windows down and repeatedly honking his horn. So the officer turns around, turns on the overhead lights to signal that he should pull over. He's about 100 feet away from his home at that time. So rather than stopping, the suspect continued in his driveway and entered the attached garage. So very similar facts situation. Some violation observed, an attempt to make a traffic stop, fleeing in the vehicle and fleeing on foot into a home. And in that case, the U.S. Supreme Court held that the entry was not constitutionally allowed and because it was a misdemeanor situation. But the majority, even addressing the Santana fleeing felon rule, stressed that the reason for the hot pursuit rule is because of the need to prevent escape or harm to others or destruction of evidence. And let me read you a statement out of Langley, California. Well, the amicus brief suggests, quote, a flat rule permitting warrantless home entry when police officers with probable cause are pursuing any suspect, whether a felon or a misdemeanor. And the majority says, we disagree with that broad understanding of Santana. And they seem to kind of be undermining whether the hot pursuit rule should even apply to felony situations absent those emergency circumstances. So I guess, again, are there any of the standard emergency circumstances that were present here?
Your Honor, I think that it was the defendant's concerning erratic actions and that he was physically assaultive towards the police. I don't think that it was either court's intention, those other cases, that somebody can simply reach a safe place, like in a game of tag, where, you know, if I can push the officer and shut the door and go in a dark house, then suddenly they can't come after me.
Well, no, nobody's suggesting
I just committed 2 felonies.
Nobody's suggesting that. It's not Ali oxen home free or something, because the officers are not faced with a choice of entering without a warrant or letting him get away with it, right? They have a third option: get a warrant. What about that situation prevented them from doing so?
And again, Your Honor, I think that what distinguishes this situation from those situations is you have somebody who just became physically assaultive towards law enforcement, and what is he going to do next? And we do not know what's in his house, and what he's capable of based on the actions and decisions he's made up to those points.
Judge Gauthier disagreed with Ms. Goodrich, emphasizing that the officers had a third option and could have obtained a warrant to legally enter the house. In light of Michigan Supreme Court precedent under People v. Hammerland, Judge Gauthier noted that the judiciary rejects a broad, flat interpretation that would permit warrantless home entries whenever a suspect flees or retreats across the threshold. While Santana established that officers in hot pursuit may enter a residence, the judge emphasized that this rule was never meant to be a blanket exemption that strips the home of its fundamental constitutional protections. Instead, Santana relies on the existence of specific exigent circumstances, such as preventing immediate escape, protecting against harm, or stopping the destruction of evidence. Because those emergency factors were absent once officers secured the perimeter and waited outside, relying on a broad reading of the Santana rule does not legally justify the warrantless entry in this case. When asked directly by the judge, Ms. Goodrich relied on officer safety, alleging that during the initial entry, Mr. Eisler pushed the officer and fled into a dark house, creating an unpredictable threat. However, under the objective reasonableness standard established in Brigham City versus Stewart, an emergency or safety exception requires an objectively reasonable basis to believe an immediate, such as concrete threat or gunpoint. Here, fear in the dark does not constitute as a safety issue.
Defense moves to suppress evidence obtained by police when they entered the defendant's home. They observed a traffic violation, a civil infraction of a headlight out. They turn around in the vehicle, turn on the lights. There may be some factual question for a jury to sort out about whether there's enough evidence to convict beyond a reasonable doubt of the fleeing and looting, given the distance that was involved by the time they got turned around or not. But he does cut the lights out, which suggests some knowledge that they're trying to stop him. He pulls in a driveway, and then the police are arriving sort of at the foot of the driveway while he's getting out of the car. There's some testimony at the preliminary examination that there's a verbal command to stop. It's a little unclear how much in the house he is when they're giving those commands. The officer testified, I think by his estimation, that the defendant was 95% inside the home when they're arriving at that door. And so then when he goes inside, the officers follow. They clear the first floor. He's not there. They presume that he's upstairs for, I think, a really prudent decision of officer safety. They retreat from the first floor to kind of take their bearings and come up with a plan. And they await backup to arrive. The testimony was that backup arrived within 5 or 10 minutes, and then within 10 or 15 minutes of the first entry, they come up with a plan to secure the front and back door, and they make entry into the home where they order the defendant down from the second floor. He refuses at first, and I don't know whether that's a basis for any of the R&O charges, but then he does comply and come down and is arrested without further incident. The question is, did the officers have constitutional grounds to enter that home without a warrant? Because there's no warrant, there's no consent. So the only justification is exigent circumstances. And the Lang v. California case in 2021 is a very interesting case. It reminds us of the reason for the exigent circumstances exception. And they say, quote, one important exception to the warrant requirement is for exigent circumstances. It applies when the exigencies of the situation make the needs of law enforcement so compelling that a warrantless search is objectively reasonable. The exception enables law enforcement officers to handle emergencies, situations presenting a compelling need for official action, and no time to secure a warrant. And the emergencies that have been recognized are to render emergency assistance to somebody who's injured or to protect someone from injury, to prevent the imminent destruction of evidence, or to prevent a suspect's escape. And the Supreme Court says, quote, in those circumstances, the delay required to obtain a warrant would bring about some real, immediate, and serious consequences. And so the absence of a warrant is excused. The court also says, quote, whether a now or never situation actually exists, whether an officer has no time to secure a warrant depends upon facts on the ground. They caution again that the physical entry of the home is the chief evil against which the Fourth Amendment is directed, that the home is entitled to special protection. In Santana, in 1976, the U.S. Supreme Court did allow entry for hot pursuit of a fleeing felon. In the Lang case, the Supreme Court calls into question how broad that case is, because in the Santana case, there was in fact a concern about destruction of evidence. It was a drug situation. Someone knows the police are coming, they're going in the house and probably destroying the drugs. But then Lang said, well, regardless of whether Santana has a black letter rule for fleeing felons, it doesn't apply to fleeing misdemeanors. And the reason they said, quote, the gravity of the underlying offense is an important factor to be considered when determining whether any emergency exists. When only a minor offense has been committed, there's reason to question whether a compelling law enforcement need is present. So it is particularly appropriate to hesitate in finding exigent circumstances.
Judge Gauthier reinforced that the Santana rule applies specifically to fleeing felons, not automatically to misdemeanors or minor infractions. Under the exigent circumstances doctrine reaffirmed in Kentucky v. King, 563, law enforcement may act without a warrant when there is an immediate threat of evidence destruction. And under Payton v. New York, 445, warrantless entries into a private residence are presumptively unreasonable. To overcome this core safeguard, law enforcement must demonstrate strict exigent circumstances. Emergency assistance is required to treat an injured person or protect someone from imminent harm. There is an imminent threat of evidence destruction. It is necessary to prevent a suspect's escape. Here, the underlying facts failed to satisfy any of these narrow emergency exceptions. Under Welsh v. Wisconsin, 466, courts must weigh the gravity of the underlying offense. In the Michigan compiled laws 257.683, operating a vehicle with a non-working headlight is categorized strictly as a civil equipment infraction. Because the law enforcement encounter derives solely from this minor, non-criminal violation, there was no imminent danger, no felony offense, and no disposable evidence to justify overriding the constitutional protections of the home. Consequently, Judge Gauthier's ruling joins on the absence of any objective evidence that the officers reasonably believed that Mr. Eisler posed an active threat to safety or was about to harm anyone.
So here the people's position is that because the act of fleeing and eluding in Michigan is a felony, and because not obeying the lawful command to stop running is a felony, that triggers the hot pursuit of a fleeing felon rule. I'm really unsure about that, because that would mean there's no such thing in Michigan as a fleeing misdemeanant. But of course there would be. If you commit a misdemeanor and then you flee, I mean, you're fleeing from that apprehension of a misdemeanor. And I read Lang to suggest that you look at the underlying offense plus the flight. So I don't think the flight itself can be considered as the felony that they're fleeing from. You look at what are they fleeing from. If they're fleeing from a felony arrest, if that arrest begins in a public place, they can continue it into a home. If what they're fleeing from is a misdemeanor, or here, a non-criminal traffic violation, I'm very unsure under Lang whether that would allow them to enter the home to finish or effectuate that arrest under the hot pursuit rule. So, I mean, I'd be inclined to think that the first entry would not be constitutionally permissible. But I'm not sure that I need to definitively reach that question, because here the officers retreated and waited 15 minutes before going back in and did not secure a warrant. They didn't even, by their testimony, double check who owned the home or who was a resident at the home. Maybe that would be relevant, because maybe if there's, I mean, I can see if he retreated into a stranger's home and there's other occupants in there, you know, that would obviously be an emergency for entry. But the officers made no attempt to determine who's the occupant or resident of that home. I think that 15 minutes while they're forming a plan it's really hard to square those facts with all of the statements in Lang about the reason for the exigent circumstances exception. Time has got to be of the essence. There's got to be a true emergency happening of either preventing harm to a person, preventing imminent destruction of evidence, or preventing escape. None of those things are present here. He's inside the home and they're out. They can secure the perimeter and get a warrant. That happens from time to time, where police officers secure a perimeter and obtain a warrant. And there's nothing under these facts that would have prevented them from doing so. So here there's no showing of any exigent circumstances that would have allowed the second entry to the home. The first entry, I'm inclined to agree with the defense, but I don't think we need to reach it. I don't agree with the prosecutor's position that because the first entry is permitted, then they can retreat and enter a second time. It's really hard to see what the limiting principle of that rule would be. Could they wait 30 minutes or 3 hours, or how many times could they go in without a warrant? I think once they retreat, it's now an entirely different situation. There's no emergency present that would prevent them getting a warrant. And this second entry is what resulted in evidence being obtained. So I would grant the motion to suppress any evidence obtained by the officers by virtue of their second entry into the home.
Judge Gauthier granted the defense's motion to suppress. According to the judge, the officers made no attempt to verify who owned or resided in the property. Ms. Goodrich argued that the moment Mr. Eisler ignored commands and ran, he committed Michigan felonies, specifically fleeing and eluding and resisting an officer. Under the hot pursuit doctrine, chasing a fleeing felon allows police to cross the threshold into a home without a warrant. Judge Gauthier, on the other hand, pointed out that if flight itself creates the felony that justifies a warrantless entry, then every minor traffic infraction in Michigan would automatically turn into a felony chase, effectively eliminating the concept of a fleeing misdemeanor. With that, Judge Gauthier granted the motion to suppress all evidence obtained during the illegal second entry. In the end, the case ended up dismissed. This case demonstrates the importance of the applicability of the law and the value of Fourth Amendment protections against warrantless home entries. Mr. Gilbert explained why the officers had no authority to re-enter the residence without a search warrant, asserting that any initial exigent circumstances had dissipated after officers stepped outside, secured the perimeter, and waited 15 minutes. With that point of view, Judge Gauthier grounded his decision on the motion in Lang versus California, explicitly stating that hot pursuit does not grant a right to breach a private dwelling, and because no active emergency existed during the second entry, a judicial warrant was required. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.